Hi, thank you for joining us and welcome to this installment of David W. Klossing's Clarifying Tax Situations.
What do you need to know as a taxpayer where you've got tax litigation against the IRS? First of all, when might you need to litigate? Well, litigation becomes necessary when you go through an audit and the IRS either relies on the wrong facts or the wrong law and reaches a wrong legal conclusion, and as usual, that legal conclusion leads to additional tax liability. You may need to litigate that issue to get it to go away. How does the litigation process begin? Well, first of all, if you have an audit and you're sitting there looking at the auditor's report and they're asking you for $300,000 of additional tax, and they're either assuming facts that you know aren't true, or they're stating the law that your tax advisor is telling you is the incorrect law and they're reaching a wrong conclusion, you really only have two choices. You can either allow them to assess the tax and pay it, or fight it. If you choose to fight it, what you're going to need to do is file a tax court petition. If you file a tax court petition, what's going to happen is that's going to get you into the IRS appeals process. The IRS appeals officers are taught to weigh the hazards of litigation. For example, if the appeals officer thinks they have a 50% chance of winning the issue in litigation, they might be willing to compromise the amount you owe. Let's say it's a $100,000 proposed assessment down to $50,000. In other words, 50% chance of winning, they'll only hit you for 50% of the assessment. This can be achieved without litigation in the appeals process, but you need to file a tax court petition to get that opportunity. You also need to have someone who's very adept at making it clear to them that they do have hazards of litigation and that you're going to win, they're going to lose. They should settle the issue with you right then and there. Tax attorneys have an advantage in the appeals process in that while it's true that EAs, CTEC certified preparers, and CPAs can appear for you in the appeals process, attorneys are much more adept at getting the appeals officer to realize that they have hazards if they litigate the issue. And who's going to be more convincing that you intend to litigate than a tax attorney who's ready to take it there? Matter of fact, if you can't get the result you're looking for in appeals, only an attorney can take it to the next step. There's one more opportunity to settle the case without litigation, and that's once the appeals officer washes their hands of the issue and passes it on to Chief Counsel's office, only an attorney can show up and interact with the Office of Chief Counsel. Why specifically you would want to use me in litigation is approximately 1% of attorneys are also CPAs. I'm in that 1%. I understand it from the accounting to the tax preparation to the interaction with the IRS and the audit to the appeals process to trying to reach a settlement with Chief Counsel's office, and ultimately if you have to go to tax court litigation, I used to be the chair of the California State Bar Tax Procedure and Litigation Committee. I'd love to take you there. If you actually get to tax court, there's only two ways somebody is authorized to represent you in tax court. Either they're an attorney that's admitted to practice in tax court, or they're somebody that have passed the tax court examination, which is rumored to have a 2% pass rate. There are a few CPAs that are sophisticated enough to pass the tax court examination, but ordinarily they've been to law school, they failed the bar, but they managed to pass that exam. What are the basic requirements in order to litigate your case in tax court? The first thing you need to know about litigating in tax court is the only federal court where a tax issue can be litigated where you don't have to pay the amount in dispute. You get a notice of statutory deficiency from the IRS, a 90-day letter. That is the amount they're saying of additional tax that is due because of the audit or whatever type of legal action they took against you. And the only way to stop that amount from becoming legally due and collectible is to file a tax court petition within the 90-day period that the notice of deficiency allows to file a tax court petition. Because of this, the most common type of tax action brought before the tax court is a deficiency action. Again, in order to bring a deficiency action, the taxpayer must have received a 90-day letter. Then they must have filed a tax court petition within the 90 days allowed within that letter. First thing I need to warn you about is the unauthorized practice of law for any other professional other than a tax attorney to file a tax court petition. CPAs, EAs, other types of tax professionals are known to file tax court petitions all the time. The way they get around the unauthorized practice of law is to set you up to go pro se to tax court. In other words, their information is nowhere on the tax court petition. First thing I need to warn you about, if the person filing your tax court petition doesn't know what they're doing, they can actually lose legal rights for you because any issue not stipulated in the petition will not be heard by the tax court, including penalties and interest. The next thing I need to tell you is that interest will continue to accrue the entire time the amount at deficiency is being litigated. So my advice to you is, if you have any doubt whether you're going to win your petition or not, is to post up a bond that covers the amount at issue to stop the running of interest. Interest runs at about 9% simple interest a year. It's not cheap. The most important thing for you to know is that the tax court's very jurisdiction to hear a case turns on you filing that tax court petition within 90 days. If you trust any other professional to do this for you, make sure they file within that 90 days or your issue is moot. Remember, an IRS deficiency comes to you on something the industry calls a 90-day letter. If you don't file a tax court petition within the 90-day period that's running when you receive the letter, you lose your rights to go to tax court. Now, does that mean you're completely without hope? What you would have to do is pay the amount in dispute and then sue for a refund, and that would put you in a different court altogether and you would be at a significant disadvantage. Yes, it has legal consequences that aren't kind. If the 90-day letter runs unopposed, you do not file a tax court petition. Even though the assessment could be based on the wrong law, on the wrong facts, it becomes legally collectible and the government can post up liens and begin the levy process to collect. There's only one exception to this 90-day period. If a taxpayer happens to be living outside the United States, they get 150 days to respond to the tax court petition, not 90 days. The deficiency notice typically contains 3 different items. First, it tells the taxpayer that they owe additional taxes, penalties, and interest. Second, the taxpayer is given a legal description of the grounds in which the IRS is assessing the additional tax. The 90-day letter usually includes a legal description of the legal grounds on where the IRS is justified in assessing the additional tax, penalties, and interest. Third, the letter is typically sent out at the conclusion of an audit. The IRS is required by law to state specifically on the 90-day letter the last day in which you have to file a tax court petition. Make sure your advisor does not miss this date. The tax court will find a notice of deficiency valid if sent by the IRS via certified mail to the taxpayer's last known address. Under the law, a taxpayer's last known address is the address on the last return that was sent to the IRS. Even if you posted up a change of address with the post office, this is not effective unless you gave the IRS direct notice that you were changing addresses. Again, change of address supplied at a post office is ineffective for this purpose. You need to specifically let the IRS know if you've moved from the address where you were last filing returns from. Who can represent a taxpayer in tax court? Number one, the taxpayer can go pro se. Okay, that means they can represent themselves. Or they can be accompanied by an attorney. Any other type of tax professional may be able to show up and be viewed as a witness, but they can't represent you in tax court. I need to explain to you that there's a 70% loss rate in tax court. 70% of the cases that are brought up by taxpayers in tax court, the tax court holds against the taxpayer. Most of these people are pro se. You might want to think twice about hiring a tax professional if there's significant dollars at issue and you believe the IRS is wrong. Why not take a tax attorney with you? The IRS is going to be represented by counsel out of the Office of Chief Counsel. Simply said, they will have an attorney representing the IRS. Ordinarily, the agent that audited you will show up as a witness, and the government's going to send an attorney to prosecute their case out of Chief Counsel's office. It's very important that the tax court petition be filed in the correct place. It's only valid if it's sent to the tax court. Matter of fact, the clerk of the tax court in Washington, D.C. There are very specific instructions to follow in order for a tax court petition to be legally valid. And you need to know right off the bat, you are not entitled to a jury trial in tax court. Your case will be heard by a federal tax court judge. It's imperative that you have some proof that your petition actually was served upon the government. I suggest you send your tax court petition via United States Postal Service certified mail return receipt requested, or by another tax court approved delivery service. But most importantly, be able to prove that you sent it. It is the postmark that will determine whether a tax court petition is mailed within the 90 days, not the date that it is received by the tax court. Since timely filing of your tax court petition is a jurisdictional requirement of the tax court, it is imperative you could prove when you mailed your tax court petition. What happens if it arrives late, or worse yet, doesn't arrive at all? You need to be able to prove when you mailed it. That controls. Your tax court petition must contain a clear and concise assessment of each error made by the IRS on that 90-day letter. Otherwise, you lose rights to contest that issue. In order to prevail in tax court, you need to spell out each instance where the IRS has got the law wrong or the facts wrong in reaching the position taken on the 90-day letter. Here's the scary part. Any issue that you don't contest in your tax court petition is deemed conceded, and the IRS is right on that issue and you're wrong. All of these convoluted rules are the reason why you would be wise to visit with a tax attorney and discuss your issues before you try and handle this thing on your own pro se. By the way, going pro se is a horrible idea given that 70% of the people who go to tax court lose. As part of your tax court petition, you must supply a statement of taxpayer identification that associates your Social Security number with the petition and is not a public document. This statement is really important because you should redact or black out your Social Security number on every document you send as associated with your petition, because tax court petitions are a matter of public record and identity theft is a concern. The taxpayer must include a $60 check to the tax court. If that check bounces, they may not accept your petition. You are also required as part of your petition to designate a place where the trial will be held. If you fail to designate a place for the trial to be held, the IRS is likely to choose the location of the trial in its answer to the tax court that may not be convenient to you. The tax court also imposes formalities on the IRS, but I can guarantee you the IRS Office of Chief Counsel understands and knows how to comply with these formalities much better than you can on your own pro se. First, the IRS is required to respond to the IRS in a document called an answer. The IRS is required to file its answer within 60 days of receipt of the petition, or agree to the tax court petition filed by the taxpayer within 45 days. The IRS is also required to specifically admit or deny each allegation made in your tax court petition. The IRS's answer may claim a lack of specific information. If they do that, it will be treated as a blanket denial of any allegation made in your tax court petition. Any material allegation you make in your tax court petition that is not expressly denied by the IRS in their answer is deemed admitted by the tax court, and you win on that issue. Chief Counsel's answer to the tax court to your tax court petition must give you notice as to any defenses they have to your allegations, and clearly and concisely relate to the tax court any facts that they are relying on in support of that defense. The answer must include any affirmative defenses to the claims made in your petition and any cross allegations of fraud against you. If the IRS comes back with an allegation of fraud, you need to hire a guy like me more than ever. I'm specifically trained in criminal tax defense. The affirmative defenses available to the government include res judicata, collateral estoppel, waiver, duress, fraud, and the statute of limitations. These are all legal concepts that the layman, pro se taxpayer will not get, will not understand. You need someone who's educated in these issues on your side. Ordinarily, you're not required to file a reply to Office of Chief Counsel's answer to the tax court petition filed by you. All the allegations included in Chief Counsel's answer are deemed by the tax court as denied by you automatically. If this action is taken, the petitioner has 45 days to file a reply to the government's answer. I believe it's in every client's best interest if I can reach an acceptable result through the settlement process to resolve their dispute without my client incurring the cost of litigation. I will do so wherever possible. Fortunately for my clients, the government has a 96% settlement rate, and I prefer settlement over litigation. Again, 96% of tax court cases are settled without a formal trial. Fortunately for taxpayers, both the IRS and the tax court encourage settlement to reduce the burden of the tax court. Ordinarily, after the IRS files its answer, your case is referred to the Appeals Division of the IRS for settlement consideration. During this period of time, the IRS Appeals Office will then assume exclusive jurisdiction over the settlement of your tax controversy. But however, if you cannot reach a settlement over your controversy within 6 months of your trial date, they will refer the case on to the Office of Chief Counsel. At that point, no other tax professional can help you other than a tax attorney. Who has the burden of proof in tax court litigation? Well, this is the reason why 70% of the taxpayers that choose to litigate against the IRS lose. You have the burden of proof. How are you to establish your burden of proof without a tax attorney? If you go pro se, you're not trained in the law, you're not trained in evidence. Frankly, you're fighting David and Goliath, and you're going to lose this time. The Bible's not on your side. However, I'm David, and I'm used to taking on Goliath. Unfortunately, 95% of the time, the burden of proof is initially on the taxpayer. Unless the burden of proof is placed on the IRS under tax court rule or by statute. The biggest problem with going pro se against the IRS in tax court is that the IRS notice of deficiency is presumed to be correct. The IRS's determination, as stated in the notice of deficiency 90-day letter, is presumed to be correct by the tax court, and it's an uphill battle to change that presumption in your favor. It is the taxpayer that bears the burden of proof to prove to the tax court that the IRS is wrong and the taxpayer is right. In cases involving income tax, estate tax, or any other type of tax, the burden of proof may be shifted to the IRS if the following conditions are met. First, you must be able to prove to the tax court that there are sufficient facts in your favor and evidence in your favor to support an assertion that the government could be wrong. Second thing you need to do is prove to the tax court that you kept sufficient records to support your position, to overcome the presumption that your record keeping is a cause of the problem. Third, you need to be able to show sufficient cooperation with IRS requests for information to support your position. Fourth, it helps where you can show the tax court that you're a corporation or a partnership with net worth of $7 million or less. This presumption within the tax court that the IRS is automatically correct does not apply to certain issues as delineated as follows. The IRS has the burden of proof on any new issue raised in the litigation that weren't on their original 90-day letter. The IRS bears the burden of proof on any increase in the underlying deficiency brought on the 90-day letter. The IRS bears the burden of proof on any affirmative defenses raised in their answer. And lastly, the IRS bears the burden of proof on any allegations of fraud. What type of tax issues can be successfully litigated? Most tax court litigation breaks down into two major types of litigation. Deficiency litigation, where the government is assessing a deficiency against you and you're trying to fight off that deficiency. And refund litigation, where you believe you're due a refund based on an incorrect position taken by the IRS. Again, a deficiency action can only be filed in the tax court, where you don't have to pay the amount at issue before you litigate. A refund action, on the other hand, can only be filed in U.S. District Court or a U.S. Court of Federal Claims. What is behind a refund action is you're basically asserting that you have overpaid your taxes and you are requesting or demanding legally a refund. Which federal court should I choose to litigate my tax issue and why? Your controversy can be litigated with the tax court, the U.S. District Court, or the Court of Federal Claims. It is very important that you consult with counsel in choosing which federal court to litigate your tax issue, because the court that you approach must have jurisdiction to hear your issue or you'll never get off the ground. Each court has limited jurisdiction or a limited ability to hear certain types of issues. You must choose the proper court to bring your action. The following are the factors that sophisticated tax counsel will weigh in choosing which court to bring your litigation in. The first issue that I like to look at are the settlement possibilities. Different federal courts offer differing opportunities to settle the issue without having to litigate it. Which federal court should I choose to litigate my issue in and why? Well, the first consideration is certain types of federal courts are used to hearing certain types of cases and they may or may not have tax expertise. The court with the most amount of tax expertise is the tax court because this is the only type of case they hear. The federal district court and the Court of Federal Appeals hear certain types of tax cases, but they hear every other issue under the sun besides tax, and they may or may not be experts at tax depending on the judge that hears your case. The tax court is the only court that hears solely tax issues and is staffed by tax specialists. The complexity of the tax issue is also a major consideration in selecting a federal court. If it's a highly complex tax issue, you want to be in tax court, not one of the other courts that may or may not have that expertise. The legal precedents that you're going to rely on also can dictate which court you're in. If you can find legal precedents with the district court or with the Court of Appeals that are more helpful to you than tax court, you might want to go with those other courts. The prior decisions of a court give a lot of insight into the future decisions of that court. For example, if a case is brought in tax court that has very similar facts to your case and identical law as is driving your case, and that case is on your side and that's in the tax court, we'll file in the tax court hoping to get the same treatment as was afforded in the case that we're relying on, the precedent. What's also important is the jurisdiction of the case. Certain federal courts are enumered with certain types of jurisdiction or the power to hear certain types of cases. If you don't want to pay to play, in other words, you would rather litigate the issue before paying the tax that's at issue, the only court available to you is the tax court. If you're capable of paying the tax and then suing for a refund, the federal district court and the Court of Claims are available to you. Also, certain types of cases can only be heard in tax court and vice versa. The Court of Federal Claims and the Federal District Court are the only courts that have jurisdiction to hear refund claims. If your issue is that you've paid taxes to the government that you feel you've paid unfairly and you want a refund, you can't litigate that issue in tax court. So in a refund action, taxpayers are usually after the tax they paid plus any penalties and interest that were taken from them unreasonably or unfairly or illegally. Those are refund claims. The tax court has jurisdiction to review the denial of an abatement request of interest or penalties, to review partnership actions, to redetermine interest and deficiencies, to review disclosure actions, to modify decisions in estate tax cases, to review certain declaratory judgment actions, to review IRS determinations of innocent spouse treatment, to review jeopardy assessments, levies, or assessment actions, collection issues, to determine whether a worker is an independent contractor or an employee, to determine transferee or fiduciary liability, to review collection due process appeals, to review actions for administrative costs. Discovery procedures. Discovery procedures are the methods whereby a taxpayer obtains information from the government that's helpful to making their case in tax court, and vice versa, where the government obtains information from you to further their position in tax court. In tax court, the voluntary information exchange between the government and the taxpayer is encouraged. Formal discovery procedures are discouraged. Therefore, the ordinary information exchange is between IRS personnel and the taxpayer or through written letter requests. The slimline discovery procedures used in tax court can work either for a taxpayer or against a taxpayer. They can work for you in that they are typically easier to comply with than other types of litigation and will save you time, energy, and money. On the other hand, it may be much more difficult to get the information you need to prevail in tax court because you do not have a lot of forced discovery procedures to use on the IRS.
Thank you so much again for your time and interest in how we may be able to help you. Please don't hesitate to call if something is worrying you. We would be very happy to help. Just call or email for a reduced rate consultation.